former executive director of the National Solid Waste Management Authority (NSWMA), Jennifer Edwards is to be paid 3 years' salary and emoluments after she was unjustifiably dismissed by the government agency in 2015, the Industrial Disputes Tribunal, IT, has determined. Edwards, who first took her dispute with the NSWMA to the Ministry of Labor and then to the IT after she was severed from the agency in March 2015, is to be paid the 3 years' basic salary to cover the period from February 27, 2015 to February 26, 2018. She is also entitled to pay in lieu of vacation leave that she would have earned for the same period. The award was made by the IT on May 9, 2018. It did not award interest since it does not have the authority to do so. The tribunal hearing the matter comprised Chairman Charles Jones and members Errol Beckford and D. Trevor McNish. The IT made no ruling also to claims for motor vehicle upkeep and laundry allowance. Although it was not stated in the findings, Edwards at the time was earning around a $5.1 million annual basic salary, which means that she would walk away with over $15 million in compensation. The NSWMA was represented by attorney-at-law Laxton Robinson and legal officer Tova Hamilton, while Edwards was represented by industrial relations consultant Senator Lambert Brown. It is still uncertain as to whether or not the NSWMA will contest the decision. Edwards, a one-term member of Parliament for St. Catharines Southwestern who serves as president of the People's National Party's Women's Movement, was employed as executive director on a 3-year contract on February 27, 2012, 2 months after the PNP won the general election of December 2011. The contract expired on February 26, 2015, with Edwards continuing to perform her duties as executive director. The facts outlined before the tribunal were that Edwards was employed by the NSWMA on a fixed-term contract that ended on February 26, 2015. She continued to operate as executive director, consistent with the terms of the expired contract, although she did not hear from the NSWMA's board about her employment status. She was, however, written to on March 18, 2015 by chairman of the board, J. Steve Ashley, telling her that a decision had been taken to offer her a 1-month contract which would expire on March 26, 2015. Evidence presented before the tribunal, which sat to hear the matter 17 times between April 4, 2017 and January 31, 2018, stated that Edwards did not accept the 1-month extension, and Ashley wrote to her advising her that based on discussions at a board meeting, her services would no longer be required after March 26, 2015. It was then that Edwards took the matter further. The tribunal in its findings, a copy of which was obtained by the Jamaica Observer, said that neither prior to the ending of the contract nor at the end of the contract was Edwards contacted by the NSWMA regarding her employment status. Discussions were held with various persons and bodies with a view to settle the matter, but with no success. As a result, the Ministry of Labor has referred the matter to the Industrial Disputes Tribunal for determination and settlement, the tribunal stated. According to the tribunal's findings, the evidence presented showed that the NSWMA knew before February 26, 2015 that Edwards' contract would have expired when the NSWMA's Corporate Services Director wrote to the Human Resources Manager to instruct that gratuity and other emoluments due to Edwards be paid to her. In response to that pending issue, the tribunal stated that on February 24, 2015, the company's human resources manager Chelsea Shelley Vernon wrote to the financial director stating the following: "Please see attached, Memorandum dated February 23, 2015, from the Director of Corporate Services giving instructions to prepare gratuity and other emoluments for the Executive Director, Ms. Jennifer Edwards. In this regard, the Human Resource Department is requesting that the following be done: 2. Payment in lieu of 40 days vacation leave earned and not taken for the contract period. 3. Gratuity calculation for the period February 27, 2014 to February 26, 2015. Terminal gratuity on 40 days vacation leave to be included. Be it said that such evidence demonstrates that the NSWMA was at all material times aware of the fact that Ms. Edwards' contract would have expired on February 26, 2015. The NSWMA had a duty to address this matter and did not. Therefore, the blame cannot now be placed at the feet of Ms. Edwards. A detailed description of the functions and duties that Ms. Edwards continued to perform from February 27 to March 26, 2015, indicates to the tribunal that the NSWMA accepted that Ms. Edwards was an employee and assigned her duties, which she carried out accordingly. It is submitted by Ms. Edwards that a renewed contract had come into being on February 27, 2015, pursuant to Term 4 of the expired contract, which states the following: 4. Renewal of this contract, while not automatic, will be subject to the requirement for the continuation of service. This is interpreted to mean that the contract will be renewed providing there is the requirement for continuation of services. The conduct of the parties, in this regard, leads the tribunal to the conclusion that there is merit to this submission. After the expiration of the contract, Ms. Edwards performed her normal duties with the acquiescence of her employer, the NSWMA. Even more, when the NSWMA offered her a one-month contract 21 days after the 26th February 2015, she refused to accept it, and without demur, the NSWMA allowed her to continue in the performance of her normal duties. The evidence indicates that there was the requirement for the continuation of service, and Ms. Edwards was providing that service through the performance of her normal duties. The tribunal also finds persuasive the following passages quoted from the Australian case by the Western Australia Industrial Relations Commission in 2017, case of Steve Burke Transport Pty Limited v Toll Transport Pty Limited. Parties who have made an express contract to be in effect for 1 year, or any other stated time, frequently proceed with performance after expiration of the year without making any new express agreement of extension or otherwise. From such continued action, a court may infer that the parties have agreed in fact to renew the 1-year contract for another similar period. Another useful authority the tribunal stated, cited by Corbin, Steve v. Bushy, the Supreme Court of Arkansas, having stated that in determining whether tacit but actual contract exists, the prior course of dealing between the parties is to be considered, went on, when an agreement expires by its own terms, if without more the parties continue to perform as before, an implication arises that they have mutually assented to a new contract containing the same provisions as the old, and the existence of a new contract is determined by an objective test, that is, whether a reasonable man would think, from the actions, that they intended to make a new binding agreement. In such a case, when the parties continue to do business together, their conduct may permit, or even constrain, a finding that they impliedly agree that their rights and obligations should continue to be measured as provided in the old contract. New Torque Telephone Company v. Jamestown Telephone Corporation. The NSWMA's lawyers had asked the tribunal to dismiss the claim on the basis that Edwards' contentions were erroneous and unsustainable, suggesting that there was a binding 1-month contract between Edwards and the NSWMA from February to March 2015. The tribunal found that there was no valid one-month contact between Edwards and the NSWMA between February and March 2015. It said that no evidence was put forward by the NSWMA that the organization engaged staff on a one-month contract basis.